Welcome and thank you for joining us for part one of our four-part on-demand learning series focused on estate planning. My name is Alana Dandino, and I am the manager of virtual instruction here at Howard County Library System. We are excited to partner with King Hall LLC, a law firm located in Ellicott City, Maryland, to provide you with this educational resource. With me today, I have two of King Hall's associate attorneys, Kelly Raynaud and Michael DeVay, who will talk you through the first installment of this series, Estate Planning 101. In this episode, we will discuss one of two primary approaches to estate planning, the will-based approach, and discuss the advantages and disadvantages of employing this strategy and approach to estate planning, including the roles of probate and the orphans court in a will-based approach. Attendees of this course will walk away with the understanding of what a will is, who can make a will, how a will is executed, and important things to consider when creating a will. Before we begin, I would like to provide you some background information about King Hall. Garrett King and Andy Hall have worked together since 2009 and came together to form King Hall LLC in 2016. Since that time, the firm has grown to help families, fiduciaries, and business owners carry out their legal responsibilities and protect their assets and objectives. The goal of King Hall, as it has grown, remains the same as when it started: to help families protect everything that is important to them through comprehensive fiduciary representation, estate planning, guardianship, and litigation. The firm aims to provide peace of mind that when it comes to knowing your future is secure. All right, so with that, I would like to hand it over to Kelly and Michael.
Thank you, Alana. Most people think of an estate plan as simply planning for the distribution of your assets after you have passed through the creation of a will. However, a well-drafted plan consists of more than a will and should also include an advanced medical directive, power of attorney, and in some situations, a trust. The idea is to have a plan that is usable, flexible, and meets your needs for a long time to come. Together, these documents allow you to safeguard your goals, protect your values, and indeed avoid or at least delay guardianship.
So in this series, Kelly and I will discuss many of the estate planning options. The first option we will discuss, and perhaps the most common, is the will-based plan. We will also explore the role of the Register of Wills, sometimes known as the Orphans Court, as a neutral third party that oversees the process of probate, and how this can slow matters down on the back end of the process, but provide an impartial auditor. This can be an effective tool despite its slow nature if you are worried about conflict among heirs. So let's discuss the will-based estate plan in some detail. In order to do so, we will explain what a will is, who can make one, how it's done, and things to consider. So what is a will? Simply put, a will is a legal document that directs where property will be distributed upon death. Who can make a will? You must be 18 to execute a will and have the requisite capacity to do so. Please keep in mind that the capacity requirement is relatively low. And be aware that if you have assets and you are able to identify to whom you want those assets to be given upon your death, then you likely have the requisite capacity to execute a will. A common scenario when a capacity issue comes into play is when a loved one is diagnosed with dementia. The question begs, can that person still execute a will? The answer is, it depends. As you may know, dementia runs on a spectrum, and therefore so does that person's capacity. It is a moving target, so to speak. The bottom line is, if you have stuff and you know who you want to give it to, then you can likely craft a will. Kelly, would you like to discuss how the process is undertaken?
Sure. Making a will is actually quite simple. Think about what you have and who you want to have it after you pass. Write all of that down, sign at the bottom before two witnesses, and have those witnesses sign as well. That's it. Although it is relatively easy to craft and execute a will, there are some important considerations to keep in mind. For instance, who will administer your estate? In other words, who will ensure that all those things you wrote down in your will actually happen? In the state of Maryland, that person is called the personal representative. In other states, that person might be called the executor. Either way, this can be a complicated job, and that is something to consider when naming who it is you would like to be your personal representative. Another important consideration is who will inherit and how much. One must be careful when creating lopsided inheritances or disinheriting anyone expected to inherit, as this can create acrimony and, as we've seen, litigation in the future. If you have a particularly large estate, think about the ability of the person you want to inherit to handle that inheritance. Same if you have a complex asset. Consider also if there's anyone that you would like to particularly provide for if they maybe have a disability. Once you have your will, you may ask yourself, how long does this last? And the answer is, it's valid until you either revoke it or change it. If your will is lost or it's destroyed, in the eyes of the law, it's considered revoked. Michael, what are some of the reasons you would want to change your will?
Sure. So there are a number of reasons one would want to consider when modifying their will. A modification to a will that's already been executed is called a codicil. Consider a codicil when your marital status changes, property you own changes in any significant way, if any of your beneficiaries pass away or become incapacitated, if the person you name as your personal representative, again, this is that same person that could be called an executor in some states, if that person is no longer able to serve, that would be a good reason to modify your will as well. Or if you change your mind about any substantive provision of your will, you should consider changing it. As a general rule of thumb, we do advise assessing your will every 5 years and or after a significant life event, such as the ones previously discussed.
So then what? You've made your will. When you pass away, what happens? The answer involves probate. This becomes the responsibility of a personal representative and is handled through the court. The very first step is that someone, usually your named personal representative, but not always, files a petition with the court. That petition asks the court to accept your will as valid, to appoint a personal representative, which is usually, but not always, the one that you've named in your will, and to open up an estate. It can be a regular estate or a small estate. As you might expect, small estates typically take less time to administer and have fewer steps. Michael, what are some of the important steps when administering an estate?
Certainly. So please keep in mind that this process is both complex and public. So I'm going to try to hit the highlights as far as steps go. First and foremost, and as mentioned previously, the Register of Wills serves to oversee and audit the administration of an estate. This is to make sure the estate is administered properly and pursuant to Maryland law. Notice must also be given to all heirs. Notice is often effectuated via publication in a legal newspaper such as the Daily Record. The public nature of this process keeps the personal representative in check, but can also overwhelm that personal representative. As stated, the process is very taxing on the personal representative. So often it's started without the involvement of counsel. We generally find that people come to us mid-process as the complexity ramps up. There are also costs associated with probate, of course. There are court fees, attorney fees if applicable, and a personal representative commission. Estate tax and inheritance tax are not part of these fees. Personal representative commission percentages are fixed pursuant to Maryland law. In addition, creditors may file claims against the estate. Please note that this must be done 6 months from the date of death. And the length of time to administer regular estates varies considerably. We like to say it could take about 9 months, but there are often extensions and exceptions. And please keep in mind that wills can be challenged via a process called caveat, which must be done within 6 months of the appointment of the personal representative. Issues related to wills can also be transmitted for adjudication in the circuit court. Now to change gears for a moment, Kelly is going to discuss what a testamentary trust is.
A trust, testamentary or otherwise, is a legal relationship in which the legal title to property is entrusted to a person or a legal entity. That person or legal entity has a fiduciary duty to hold that property and use it for someone else's benefit. A testamentary trust is simply a trust that's included within your will. It becomes effective upon death. Essentially, rather than distribute your assets directly to those that you wish to inherit, they instead flow into your testamentary trust. So you might be wondering, why would I want this additional layer in between the giver and the receiver of these assets? There are some situations where this can be very helpful. For instance, under Maryland law, a minor child cannot directly receive money through an inheritance. A trust can help with this. We mentioned before, if there is somebody who stands to inherit a large sum of money or a complex asset, but you maybe have a concern about their ability to handle it wisely or manage it effectively, this is another situation where a trust can be helpful. If there is a loved one that you want to help provide for that has a disability, a trust is a great mechanism to do this without interfering with that person's right to receive disability benefits. There are some other advantages to trusts. For example, you can include a spendthrift provision. This will help protect the beneficiaries of that trust from creditors. And trusts are not subject to inheritance tax. Keep in mind that we have another presentation dedicated solely to trusts and refer you to that for more information. To wrap this up, we have 2 recommendations for you. Safeguard your original documents and share your intentions. The Register of Wills can keep that original will for you, or if you prefer, many drafting attorneys can keep the entire set of hard documents. In this digital age, it's probably wise to keep an encrypted digital copy as well. Make copies and, to the extent possible, share with those that you've named in all of these documents. Discuss your plan with them. This helps avoid any future surprises which could lead to legal disputes.
Wow, guys, thank you so much. That was so much very useful information. I learned a lot. So I do have some questions. My first question is, what happens if I die without a will?
Sure, and that's a great question because it unfortunately happens all the time. So passing away without a will is called dying intestate. There are significant implications to dying without a will. First and foremost, you have lost the opportunity or the ability to allocate how your assets will be distributed. All assets will go into probate and be distributed according to Maryland's intestacy succession laws. Further, there will be an increased expense and level of stress on your loved ones who stand to lose a portion of any inheritance to that probate process, which, if I could remind you, was very complicated as we touched on before. If you have no surviving family members, your estate will then go to the state of Maryland, which really no one wants. The line of succession for surviving relatives in intestate situations is as follows. If you were survived by a spouse but have no descendants, that is children or grandchildren, and no surviving parents, your spouse will inherit the whole probate estate. If you have a surviving spouse as well as children and or parents, your spouse will still get at least half of the estate, and the rest will be divided among the children and parents, with the children getting the larger portion. If there are no surviving spouse, but there are surviving parents and or descendants, the estate is divided among them. And it goes on from there and gets more and more complicated. As you can tell, this is set up to attempt to give your closest blood relations or consanguineous relationships a share of your estate, and the potential heirs become more and more attenuated. This obviously can create a host of issues based on your relationship with these people and whether you actually share blood.
Okay, so I have another question. Does everything pass through probate?
No, actually it doesn't. There are a number of assets that pass outside of probate. A couple of examples, common examples, are the assets that are held jointly with another person and assets that include post-death instructions. So a very common example of an asset that's held jointly with another is a home or a piece of real property that's owned by a married couple that's titled as tenants by the entirety. So how this avoids probate is the first spouse that dies. When that happens, that piece of real property passes by operation of law to the surviving spouse. And in this way, probate is avoided. Examples of assets that have post-death instructions. Checking accounts may have payable on death provisions. And if you complete these provisions, then that account holder, if they were to pass, that financial institution would know where to send those assets. Another very common example, beneficiary designations for retirement accounts. You can name your beneficiary. So if or when that account holder passes, again, the financial institution knows what is to happen with those assets. It's this way that probate is avoided. Something, though, to keep in mind, and this can trip people up more than you might think, is the scenario where you have a married couple. They designate each other in their estate planning documents, in all of their retirement accounts, financial accounts, and then years down the road, they divorce, they end up marrying other people. And this would be one of those life events that we talked about, where you would want to revisit your estate plan. You draw up new documents, naming each other. But should you forget to change a beneficiary designation on any of your accounts and you pass away, then those assets in that account that you didn't change will go to your ex-spouse. That's it.
All right, thank you. So one last question. When the court appoints someone, when would, excuse me, the court appoint someone as a personal representative that is not the person I name in my will?
Sure. So this is one of the various scenarios that we litigate in the orphans court. And this most often happens when there is a significant conflict between the personal representative and the other legatees. The removal as the personal representative is not necessarily common. It does happen and usually occurs due to one of the following. If that personal representative misrepresented any material fact in any proceeding that led to their appointment, they could be removed. They could also be removed if they willfully disregarded an order of the court, or if they've mismanaged property, because remember, the personal representative is there to protect the integrity of the estate. There are many other iterations of facts that could lead to removal, but those are sort of the main three that we see. Please note that by law, a hearing must take place prior to removal, and concurrent with removal would be the appointment of a successor personal representative or special administrator.
We hope that you found this presentation to be helpful. We have 3 others in our series: trust-based estate plan, trusts, and guardianship. Of course, feel free to reach out to us at our offices.
Absolutely.